be starting this webinar with all of you. I see that there's very interesting participation with various profiles of people attending, and I would like to warmly welcome you and our key expert here, Ingrid and Tim, that I'm going to introduce in a minute. So I would like to just say a few words about what this webinar and what we're going to discuss, and also to thank very much the European Forum for Restorative Justice, with whom we are actually launching this webinar series, I would like to say, because at Terre, at least for Europe, we were trying to see how we would actually have once every quarter a webinar on a special topic that we are actually working on. And we like the idea of doing this in partnership with one of the organizations that we actually have initiative and projects with. So today we are launching this series with the European Forum for Restorative Justice, because we have been working also on the topic of restorative justice for a while now at Terre des Hommes. We actually do not only have initiatives in Europe, but also in the Middle East and Northern Africa, in Latin America. And we have been actually wanting to see how, in line with the international guidelines and the Convention on the Rights of the Child, how we could actually have better solutions for children that are in contact with the law, and more specifically in conflict with the law. So as maybe some of you know, recently there was a very big work that has been done, and this was carried for a few months and if not a few years, which was a UN global study for children deprived of liberty, which is a very important piece of document with a series of many interesting recommendations. And only to quote one figure, that actually was one of the findings of the report of this study. Every single day, there are between 160,000 and 250,000 children in detention, if you count this every single day. And so what we are trying to do at Terre des Hommes, and what we are doing in partnership with the European Forum also, is to see how we can actually make sure that we can have less children in detention and more children benefiting from alternative to detention, from restorative measures, as this actually, with lots of extensive research, has proven to be more efficient and beneficial for the child itself. So this is why today we wanted to address this question about what is restorative justice, what are actually best practices in restorative justice and alternative to detention, what would be recommendations, ideas and inspiration that we could share with you. I see that there are indeed different practitioners here. I see that we have here in our group psychologists, we have probation officer, we have projects officer, I see community mobilization officer, so really interesting profiles. And this webinar is really intended for a large audience, from practitioners, from academics, from students, from also people working directly in restorative justice, and practitioners that are willing to understand a bit better how to really implement alternative to detention for children. So, and with us, and I'm really honored to actually present them because they are people that I have a lot of admiration for and that I'm really enjoying working with. We have Ingrid from Welzenis. So welcome, Ingrid, with us. You are you have studied child psychology, and you are expert also in juvenile criminology. You have extensive experience in as a researcher, especially on child rights and juvenile justice. We have met in another context. It was in Northern Africa, and we worked a lot on how to actually have more community-based solutions as alternative to detention. And at that time, it was really amazing to see the extensive research that you had done, and which was very beneficial for the children in the regions. So Ingrid is very much involved in developing various training packages, but also training directly a variety of professionals in the justice field, and also involved in evaluation of various practices around the alternative to detention, which is really one of her specialization. So welcome, Ingrid. And before I give you the floor, I would also like to introduce Tim Chapman. So welcome, Tim. Very honored to have you as you are the chair of the board of the European Forum on Restorative Justice. You're an independent researcher and a trainer. You have extensive experience and you actually are one of the key people in the world of restorative justice, not only in Northern Ireland, but really worldwide. And you have developed, thanks to your experience with more than 25 years in the probation world, you actually have developed various models and practices of restorative justice. And just to quote, for instance, restorative conferencing, you have published on the topic. So for people that are interested, we'll also be willing to share what Tim has published, but it's easily to be found on the European Forum and online. And so Ingrid and Tim are both going to address two aspects of what we're going to discuss today. So first, Ingrid is going to talk about various examples and ideas around alternatives to detention, and Tim is going to talk about restorative justice. And once we're going to have these two presentations, we are going to actually ask you 2 or 3 questions through a poll that is Welzenis is going to put on the screen. And then we hope to have actually time for a discussion, a conversation. And we would really encourage you in the chat box during the presentation to put your questions. I will monitor the questions that you have, and we will address all your questions once Ingrid and Tim have done their presentation. So, happy, and so the questions in the chat box. So now I'll give you the floor, Ingrid. I will mute my microphones, and then you can unmute yours. And happy webinar to everyone.
Thank you very much, Mariama, for your kind introduction, and good afternoon, or maybe some of you, good evening. Thanks for joining this webinar. And I will talk about, like Mariama already said, about diversion and alternatives to detention. So that means that we are talking about children in conflict with the law. So no other children in contact with the law, but only children in conflict with the law, and only those who are above the minimum age of criminal responsibility. So that is a little bit different in your countries, but let's say for Central Europe, we are talking about 10, which is very low actually, all the way up till 14, 15 years. So we talk about these children, and only when they enter the formal juvenile justice system. So we are also not talking about informal justice, although that is not that much in Central Europe, but in other countries, it's also relevant to talk about informal justice. But today it is about diversion and alternatives within the formal juvenile justice system. I like to start with the next slide, where you see Article 37b of the Convention on the Rights of the Child. I like to use that one to develop the different alternatives that are available, because Article 37 is telling us that arrest, detention, and imprisonment, or in one big word, deprivation of liberty, that should be only a measure of last resort. And if that's not possible, and we have to deprive children of their liberty, it should be as short as possible for the shortest appropriate time. So that actually means, if we follow the CRC, and we have to, of course, all countries in Central Europe has ratified the CRC. So we have to find alternatives so that children are not deprived of their liberty. But when we look at the next slide, then we will see that children in conflict with the law, who are above the minimum age of criminal responsibility, are not only locked up in detention centers, pre-trial and post-trial, in imprisonment, but in different kinds of facilities, let's say, and they are mentioned here. Just that you know that it is actually a much broader topic, but we will focus on detention. The next slide is something that Mariama already mentioned, the United Nations Global Study on Children Deprived of Their Liberty, and she actually mentioned the number of children in each and every day in detention, and you see it here. So when we are looking for alternatives, and we will see it on the next slide, I would like to talk about a continuum. And I hope that each and every country will develop or already in place have this continuum of 5 responses or 5 measures. Number 1, 2, and 4 are the actual alternatives: diversion, alternatives to pre-trial detention, and alternatives to post-trial detention. Those are the real alternatives. And if it is not possible to apply an alternative, and children end up in either pre-trial detention or post-trial detention, Article 37b of the CRC tells us, then it should be minimized. The time should be as short as possible, and that is number 3 and number 5. I will go through all of them one by one, and I will especially elaborate on diversion, and it will be clear, hopefully, why I'm doing that. So if we look at the next slide, but maybe let me say something before I start explaining what is diversion, and that it is really something that is really a lot applied in Central Europe, in all European countries, both without a restorative justice component and also with a restorative justice component. So later on, when Tim has done his presentation, you will understand the difference between them. But diversion in general is applied in almost every country, and actually really a lot. It is really the preferred measure, the measure of first resort. What means diversion? You see it in the first bullet point. It's measures for dealing, of course, with children in conflict with the law without resorting to judicial proceedings. That means we deal with the child before the child goes to court, before the first formal trial starts. This is the priority. This is what we have to do if possible. And when we look at the second bullet point, you see that it actually should be a very widespread practice. It should not only be used in minor offenses, and also not only for first-time offenders. Although we know in a lot of practices, in a lot of countries, it is actually applied only in those kind of cases, but the CRC and other instruments internationally are telling us, please apply diversion in much more cases, also for more serious or even for serious cases, and definitely also for reoffenders. Why? That's clear, because diversion means that all the negative effects of the formal judicial proceedings are avoided. Children don't suffer, so to say, or not suffer that much, and they also will not have a criminal record. The CRC, Article 4T, also tells us that we have to respect a lot of legal safeguards. I don't mention them there, we can discuss it in the discussion afterwards, but this is about, we need to have compelling evidence, legal assistance should be there, children should admit their responsibility, that they were involved in the crime, they should give their informed consent, and things like that. Let's look at the next slide. That shows you that diversion actually doesn't mean, and this is what some people think, maybe not you, but some of other people, they think diversion actually means that the professional tells the child, go home, be a good boy or girl again, and that's it. But that is not what we promote internationally. It's not going home as such. It is going home, going to school or to vocational training or to work, and also other obligations, other conditionals. And when you look at the title, you see diversion is conditional. And this is really something we promote. Children have to comply with certain conditions, and not just some conditions, but the conditions actually that address the problems they have, so that they can rehabilitate, reintegrate, and finally that reoffending is prevented. So ideally, children will get a diversion plan that is really tailored to their situation, to their offense, to the circumstances they are living in. Of course, the most easiest thing then is that we have a social inquiry report or a psychosocial assessment that actually shows the root causes of the child's offending behavior, for the same reason that we can tailor the diversion plan to what the child really needs. Conditions are proportionate. If a child gets diversion because he or she steals a mobile or has injured someone, we really have to take it into account what was the offense and also whether it was a first offender or already a reoffender. So it has to be proportionate to the offense but also to the circumstances. Of course, if the child fails to comply with the conditions that we agreed upon, then it's not just, okay, it didn't work, then it goes back to the referrer. The referrer can be either the police or the prosecution, and then at that level, other alternative measures can be taken, or the case goes to the next level. The police sends the file to the prosecutor, or the prosecutor can decide if there is no other alternative to take to send the case to the court. Please keep in mind, diversion is conditional. It also means that there should be someone, usually that's the social worker involved in the case manager, who actually monitors and supports the child that he or she is complying with the conditions that were agreed upon. Let's go to the next slide. Then you see some examples, not just examples I imagine, but those are really applied in countries where you are living in, but actually in the whole world. I usually divide them into three: constructive conditions, restrictive conditions, and restorative conditions. The last one, the restorative justice ones, will be discussed by Tim. And I would like to focus on the constructive ones because they are required. They are the preferred one and not the restrictive conditions. Because when we have restrictive conditions like not going somewhere, not having contact with certain people, etc., the child will not learn, will not understand what went wrong and how he can do or she can reintegrate and rehabilitate. So we are focusing on constructive conditions. Like, and you can read together with me, writing an essay on the effects of the offense that the child has committed. Going to school, to work, vocational training are very often included in diversion plans. Participating in what some people call life skill programs or competency development programs, like where the child learns how to get along with conflicts, developing self-esteem, but also more like counseling, therapeutic treatment, anger management, peer pressure programs, drug, alcohol addiction, etc. Also, it doesn't have to be that, let's say, treatment kind of program. Sometimes in the diversion plan is also included that the child should find some constructive leisure time, not to hang around, but do some sports or arts or culture and things like that. So this can be discussed with the child, the parents, the police officer, sometimes it's the prosecutor, sometimes it's a social worker, sometimes it is an interdisciplinary team, but it is discussed and agreed upon with the child what to do to tackle the root causes of the offense, and sometimes also restorative justice, and Tim will explain that. That can be part of the diversion program as well. How long it takes, how long the child has to comply with the conditions, that depends on the law of that particular country. Sometimes it's 3 months, sometimes it's 6 months, sometimes it's even longer, but that also depends, of course, what the law says, which kind of offenses are eligible. Okay, let's look at the next slide and imagine that diversion cannot be applied in a particular case of a child in conflict with the law. That means the child will go to court one day, but during the pre-trial stage, we still have a possibility to apply alternatives, and that's called alternatives to pretrial detention. That means the child doesn't go to the pretrial detention facility, stays at home, goes to school, hopefully also has some leisure time, and is supervised pending his or her trial. So this is an alternative to pre-trial detention, but only for those children who cannot be diverted. Yeah, because that was the measure number one. It means that the child is released, usually to the parents, can be a guardian, can also be an extended family member, a relative, or an other responsible adult. In some countries, I'm not sure whether that happens in Central Europe, but in some countries I have worked in, it can even be an NGO where the child is released to, and that can be either with conditions or without. Very often it is with certain conditions that the child can await his or her trial at home while going to school. What kind of conditions? I have listed them. There are more, but these are the usual ones. The child has to report regularly, weekly, every 2 weeks to the police station pending his trial. It can also be the probation office, but usually it's the police station. The child has to attend school if he or she was already going to school. Being at home at certain hours, usually immediately after school, but definitely during the evening, is something that is very often a condition for pre-trial, an alternative to pre-trial detention. Compliance with a curfew, not going to certain places like bars or Luna parks and that kind of things, or associating with certain people, usually witnesses and the victim. It can also be an agreement on paper not to contact the victim or the survivor. Monetary bill is also something that's very often a condition, but I have put it in between brackets because this is something we do not promote, because very logically it discriminates against children from poor backgrounds. So this is not what we want to use when we talk about children in conflict with the law. Let's see, when children, the next slide, if pre-trial alternative is not possible, and it is decided that the child has to go to pre-trial detention. You remember that Article 37B of the CRC states, okay, if it is unavoidable, children end up in pre-trial detention, but that doesn't mean that they have to stay there all the way up till the trial starts and during trial. There has to be a regular review whether the pre-trial detention is still necessary. If things have changed and the child can go home or to another person, a relative or somewhere else, the child has to be released as soon as possible. And again, usually that is under certain conditions. So don't keep children in pre-trial detention, review, and if possible, let them go home so they can await their trial at home and during going to school. Another pure alternative is on the next slide, and those are called alternatives to post-trial. We have pre-trial and we have post-trial detention. Other word for the same is non-custodial sentences, and also in Europe you use also alternative sentences. What it means is the child doesn't go to detention, is not sentenced to imprisonment or another deprivation of liberty, but the child can go home and is sentenced to something, to a community-based option. In the CRC, it stated that courts should have a very wide variety of possible alternatives to post-trial detention, because that means that every child can have a sentence, a non-custodial sentence, that is tailored to the situation. And of course, it also has to be proportionate. Let's look at some examples at the next slide. What can be alternatives to post-trial detention, non-custodial sentence? That can be a reprimand, a warning of the judge. That is actually unconditional. The court will tell you that he or she doesn't want to see the child back. Don't reoffend again, go home, and that's a sentence. It can be probation. That means there are conditions that the child has to comply with during a particular period of time, usually 1 year, sometimes longer. Most of the time longer Then the conditions that are linked to diversion, because this is a sentence. The child could not be diverted, so ended up at trial and was sentenced to probation, and that means in the community, but particular conditions. And in actual practice, those conditions are actually kind of the same as we have seen for diversion. The children go to similar or even the same programs when they are on probation or they are diverted. Community service is a very particular sentence. It can also be included in community hours in the diversion plan, but here it is a sentence and the child is sentenced to do particular voluntary work that benefits the community. Not that much light, it is always light work. It cannot be applied to children below 12. Otherwise, we call it child labor, and that's of course not possible. Some people say, let's try to block all the hours of the community service, let's say in the school holiday or during weekends, so that it is not that much spread it out. Of course, we also need the informed consent of the child and the parents when community service is applied. Counseling or therapy or treatment, that's another alternative to post-trial detention that can be ordered by the court. Curfew, the child is not allowed to go to particular places very often or to see particular people. This is usually linked to another one, so a combined sentence of a curfew and let's say treatment. Then we have a restorative justice order. Tim will tell you about that. And in many legislations, you see that you also have fines as an alternative to post-trial detention. But like I explained before, this is internationally not promoted because, again, it discriminates and it is also not considered to have any rehabilitative value. So this is, I should have put it between brackets, but it is actually included in many laws, also in Central Europe. Let's look at the next slide. That means that the child didn't get an alternative non-custodial sentence, but the court sentenced the child to post-trial detention. The child was imprisoned, deprived of their liberty in a juvenile detention center, or sometimes even in adult prisons. But again, you remember, what we have to do is to ensure that the child stays there as short as possible. From the early beginning, the child will be prepared for release anyway. That is one of the duties of the detention center. The sentence will be reviewed often, and it is advised that it is not less than every 6 months. Of course, you need a well-trained probation service because when the child is released, early released, or at the end of the sentence, the probation service should be there to ensure that the child can go home or has another place to live, goes to school, find a job, etc. Early release, that should be as early as possible. So we are looking for early conditional release, and if not possible, of course, the child will be released at the end of the sentence. The next slide is about restorative justice, so we can skip that one. And maybe, because I think we are all adults in this webinar, I really would like to end my presentation with a child who shows, this is actually a video of 1 minute prepared by many children. And it is a child in conflict with the law, just to end my presentation with the kids themselves and not with us talking about them. Thank you for your attention.
Here's some television.
So the question can be whether this child can be diverted, can receive an alternative, or has to be deprived of his liberty. Thanks a lot for your attention.
Thank you very, very much, Ingrid, for this nice presentation. Thank you for the video. It's interesting to see. Can we go back? What is it that we can do to prevent, this situation and provide better services? So I think that what you are presenting, it's also help all of us, for some that are already working in the area, to as a refresher also on what we actually mean. I often get asked about, but what are actually really alternative, and how people even themselves that are, when I have sometimes spoke with judges or prosecutors, and the interpretation of the alternative itself is sometimes quite wide, even though the legislation is quite clear, but the implementation of it can take really different shapes. So, and this is also the case for in the one more specifically related to restorative justice. What do we hear by restorative justice? How is it applied? And this is what Tim is going to tell us in a few minutes. I want to draw your attention to say, please write questions in the chat box so we can address it after Tim's presentation. I would be really keen to know if you have from what Ingrid has shared with us. So please don't hesitate to put your questions. Any question is super welcome. We will address it, and so I will give the floor to you, Tim, for your presentation. And so then we have something like 15 minutes, and then we can have the polls and have maybe a short discussion at the end. Thank you.
Thank you, Mariama. This is the first time I've done a webinar, so it seems a bit strange to me, just looking at a screen. But thank you for everybody who turned up to listen to Ingrid and myself. I suppose what I want to talk about briefly this afternoon is that restorative justice has a very different orientation and philosophy to the mainstream of criminal justice. And I believe if restorative justice was more integrated into the ways that we respond to children in conflict with the law, the detention rates would reduce significantly. And I want to just explain to you why I think that. Next slide. So this is the European Forum for Restorative Justice that I'm a member of, has come up with a sort of byline saying that restorative justice is all about connecting people to restore just relations. And then there's, if you click again, our definition. I'm not going to read it out to you, but I just want to highlight a few things. One, that restorative justice is different to criminal justice in that it's not sort of individualistic. It considers all those people who have been affected by an act of harm or crime. Of course, that includes the young person who may be responsible for the harm, but also his or her parents, those people that are close to them, the family, and of course the victim. I'm not going to talk a lot about the victim today, but I do want to come back to that and say that I think the reason restorative justice can reduce detention is primarily because victims are involved. And of course, members of the community can, when appropriate, be involved in a restorative meeting with the young person who's committed offense. So it's a collective response rather than individualistic response. It's also a participative approach. The young person actively participates in the process rather than being a sort of passive recipient of what the professionals are doing all around him or her. And finally, it focuses on harm rather than crime. It focuses on the harm that crime causes, as opposed to the fact that somebody has broken a rule. It focuses on relationships, and it focuses on trying to achieve a lived experience of justice. Next slide. Next. It can take place at any stage of the criminal justice process, and has done, right from the beginning, where it can be preventative, can be informal justice, informal referrals, And then going into diversion, which Ingrid has very comprehensively described. It can be a pre-sentence event which may influence the sentence and influence a judge not to send a young person into custody. And of course, it can be used even if somebody does get detention within the detention center and as a preparation to resettlement within the community on release. Next slide. What you'll find, or certainly I've found, is when restorative justice is introduced, there is a reaction from the legal professionals, because I think a lot of legal professionals, lawyers, judges, are very possessive of the concept of justice and believe that justice it belongs to the criminal justice system. But restorative justice challenges that, and I think this quotation from Eleanor Roosevelt, the wife of President Roosevelt in America, is basically saying that justice is experienced everywhere, not just in the police stations, in the courts, and in prisons. It is a universal value, and restorative justice can provide processes in which people resolve injustices, whether it's in families, neighborhoods, schools, or in the community when a crime is committed. Yes, next please. Now here's another significant change. This sort of mantra, the problem is the problem, the person is not the problem. Now I believe that the reason so many children end up in custody is because they are seen as the problem. They need to be, for whatever reason, they need to be excluded from society, from their families, from the support within the community, in order to be controlled, punished, or rehabilitated. And that's very much from the point of view that the young person in conflict with the law is the problem. Now, what is then the problem? Next slide. For us, it's harm. The problem is the harm that children may have experienced, and which may have caused them to harm others, and the fact that detention causes further harm. So those of you who are in the field will be aware of that sort of vicious cycle of children who have experienced terrible things in their lives, and as a result have recourse to criminal behavior as a means of survival or whatever. And then they get caught by the system, and then they're detained. And so far from the harm being alleviated, it's reinforced. And children often get onto a sort of career of crime. And I think our approach to this is to focus on the harm rather than the person. Okay, next slide. One way we look at harm is harm creates a rupture. It breaks things. So it interrupts people's narratives, their life. It disrupts their sense of control. Now, this could be looked at from both the victim's point of view and the young person's point of view. The young person commits an act of harm, and suddenly a whole system comes down and takes over their lives. It disrupts their sense of autonomy and also their families' sense of control over the situation. And that can create very distressing emotions within both perpetrators and victims. And if the child has already experienced trauma, that can be reinforced by their experience of entering into the criminal justice system. It can also, so far from rehabilitating and helping them to become good citizens, they may actually adopt values and morals which are criminogenic, partly because they're in detention and they're surrounded by other children who are involved in crime, and partly just because the impact of the system and the harm has shattered a lot of the assumptions that they have about society and themselves. And finally, next, and notice is once a child enters the system, that they lose resources. They have less resources that they need for a good life, and in that way they become bankrupt. That's just one way of looking at it, and it's playing around with the English language and the notion of rupture. The aim then of restorative justice is to reconnect the young person from that which they've been separated through acts of harm and being harmed. So that includes restoring, repairing, strengthening healthy relationships, restoring access to the resources they need, also restoring a more authentic and positive identity, because certainly one of the things I've encountered is that children who enter the system are stigmatized, which is bad enough because people start to treat them differently and exclude them from resources they need. But what can be even more depressing and sad is that they internalize that stigma and begin to believe that they're not worth as much as other people and do not deserve a good life. So we're trying to restore the fact that they are valuable human beings in the way that we work with them. And there's research now that it can restore neural connections through the practice of restorative justice. Just young people engaged in listening to others, seeing other people's point of view, understanding how their actions impact on other people, being able to take responsibility, apologize, be able to forgive people. Just the practice of that strengthens those neural connections that help us to have a better life. And a lot of people think restorative justice is restoring the young person to a better situation that they had in the past. For us, it's really about restoring their future, because each of those sort of ruptures, as I've called it, holds them in the past. They are judged by what they did in the past, and they judge themselves by what they did in the past. Whereas if they have a way to relieve themselves from that, they can then look towards the future. Okay, next. This is the process of a typical restorative conference process. The young person will be prepared, as will be their carers, family, and they will understand what's expected of them, and they will understand what's going to happen. They will then have a meeting with the people they've harmed, and a dialogue, and come to some sort of mutual understanding about what should be done. After that, then I think if you looked at the slide that Ingrid said about examples of diversion conditions, all of those conditions can be agreed at a conference. The victim supporters, the young person, the family can agree, these are the steps this young person should take to repair the harm, but also to get the support they need to have a better life. And what researchers find is there's a much higher level of compliance when a young person's gone through that process. They're more likely to keep to their promises than if they go to court. Okay, next. So it's a process that's inclusive, it's participative, and in my view, transformative. Okay, next. 3 general parties in a restorative process: society, the person responsible for the harm, children in conflict with the law, and the persons who've been harmed, but also those close to them. And this diagram is meant to illustrate that there's a variety of restorative processes that can be adopted depending on the context of the situation. In Europe, the victim offender mediation or dialogue process is very popular, and that you can see is at the bottom there between the people who've been harmed and the people responsible for the harm. But increasingly, especially since the Council of Europe recommendation on restorative justice, people are realizing that there's a greater range of restorative processes than mediation. Community restorative circles, restorative conferences, even restorative conversations, just one-to-one conversations that can do the work of reconnecting people and repairing the damage that the sort of rupture of harm has caused in people's lives. Okay, next. One of the things that I think restorative processes have in common is a search for truths. The criminal justice system tends to focus on evidence, legalistic facts, and that's also important. So the forensic truth is important. What happened? Understand what happened. But actually what's more important is the narrative truth. Each person who's connected to a harmful event will have a different story. And this will be very much a product of what matters to them. I often say that in restorative justice, the question is, what matters to you? in this situation. Whereas when I was a probation officer, the question I often asked was, what is the matter with you? In other words, the problem is with you, as opposed to the situation that you're in. And then what needs to be restored? If you can click again. Next. What we try and do through this dialogue and narrative approach is identify the needs. So when somebody talks about a harmful situation, whether it's the perpetrator or the victim, you're listening for the emotions. And this is a very simplistic sort of equation. If the overwhelming emotion in a story of harm is fear, then they need safety. If it's anger, it's justice. If it's anxiety, it's a need to get their life back into control. If it's shame, a need for respect. And basically the importance of that is if a restorative process does not address those needs, it will be considered unsatisfactory by the parties. So we need to know what they need prior to going into it. Okay, next. This is a quotation that I like from the Nigerian novelist Chimamanda Ngozi Adichie. All stories contain truth. The problem is their truth is incomplete. So the young person's story of what happened is truthful, but it's not the whole truth because other people are affected. And what restorative justice does is bring the other people together who each have their own truths in order to try and create a more complete truth. Next slide. And this is the importance of dialogue. People are prepared. How will they tell their stories? And what are your questions and requests of the other party? And through that sense of dialogue, you begin to develop a more complete understanding or account of what has happened, who has been affected, what are the needs, and what needs to be done. And this leads to an agreement, which you hope will be transformative. And basically, the transformation is the ability to move on in your life towards the future rather than to be stuck in the past because something terrible has happened. And that applies to both the perpetrator and to the... Okay, next. This is one of my favorite quotations from a genius of jazz, Miles Davis. And it's really, I suppose, I want you, when you look at that quotation, I want you to think about, how do we judge young people? Do we judge them by the harm that they've done, the crime they've committed, or by what they did to repair the harm? Because I think the reason why so many young people are locked up is because they're judged by an action in the past. And they're not given the opportunity to show remorse, to repair, to make amends, to show that they can be responsible citizens. And so they end up being labeled as somebody not fit to be in society. I want to give you an example from my country, Northern Ireland. Next slide. So in 2002, we passed a law in Northern Ireland saying that every young person who has committed an offence would be offered a restorative justice conference. 90% of young people agree to it. We've had over 22,000 conferences. We're a small country of about 1.8 million. So we estimate about 1 person in 20 in the population have been to a conference. It has high satisfaction rate from both victims and offenders. It also has reduced crime, particularly the more serious crime. And it was interesting that Ingrid said diversion is usually used for non-serious crime, and yet international research would say restorative processes are more effective in reducing reoffending for the more serious crimes. And what is significant to today's webinar is our detention level is very low. We used to be a country that was very punitive and would have literally locked up hundreds of young people. Small country, 1.8 million. At present, we have at any one time, between 5 and 7 young people who have been sentenced to detention in Northern Ireland. There has been a huge reduction, which is remarkable. Now, we're not sure why that's happened. There's been various things, but I believe that one significant factor is that I believe that a lot of judges do not want to send young people to prison, but they don't know what else to do, and they feel the pressure of society representing public opinion on their shoulders. Whereas if they get a report that this young person participated in a restorative justice process, and also get a report from the victim who is very satisfied and wishes for no further punishment, then judges have the courage to take the risk and not use detention. And I think that's what's happened in my country. Last slide. This is a quotation that I like. It comes from a surprising source, Audrey Hepburn, a glamorous film star. But she ended her life working for UNICEF in children's rights. And she said, people, even more than things, have to be restored, renewed, revived, reclaimed, and redeemed. Never throw out anyone. And I think that's the message that restorative justice gives to people who would lock children up because of what they've done. Thank you.
Thank you very, very much, Tim, and for all these quotes and really making like food for thoughts, and about how I really find this restorative justice process very beautiful, actually, and it's all about really shifting. And when we talk also about alternative to detention, shifting from less punitive to really something more, educative, really better for the person itself. And I know from people that have been involved in restorative processes, not only I want to say the people that have committed an offense or the victims, but all the practitioners, the mediators, facilitators, everyone involved. It has actually really an impact even on people's personal life, I think. It goes beyond the actual practice, and that is extremely interesting. So I see that we have an audience that is maybe shy in asking questions, or that your both presentation really excellent and very, very informative, and we are being requested to also share the PowerPoint with the audience. So indeed you will receive this webinar is recorded, and also you will receive the PowerPoints by email. But maybe now what we could do is maybe we have these 3 polls. I mean, it's just to have to actually see a bit what you would think. There are 3 very short questions, if you could answer this. And I mean, we will close soon because we will try to stick to this 1 hour. But if you had time to just answer these 3 questions that are appearing now on the screen. And I don't know if Vesna, you can actually put the 3 questions next in 3 boxes, or if it doesn't, I don't know.
Sorry, I have to do it one per time.
Okay,
sorry.
No worries. And then maybe for Tim and Ingrid to see, depending on the response. So now maybe to make 1 or 2 comments about it, because we thought that it would be interesting to ask you about also how it applies in your country. So you see here, for instance, restorative justice is mostly majority applied as a sentence for an alternative to detention, but very close to also diversion as a diversion measure, and not so much reintegration or preventing measure in schools.
Well, that's encouraging, I think. Generally, I think certainly for the purposes of this webinar, that's where you would want it to be, diverting young people away from the system, and if they get into the system, trying to offer an alternative to detention. So that's encouraging.
Yeah, very good. So do we go to is this poll 3 is Vesna, sorry, because are you the second poll, that is the second questions, because this is also related to what Ingrid has been presenting, and diversion alternative, is it considered as a soft option in your country? And maybe here, once we see the result, if it's majority of yes or no, and I see it's majority of yes, maybe Ingrid, it would be interesting to have a comment. There's very large majority of yeses, and to maybe make a comment about this.
It's the truth, so there is not that much to comment. But what we usually forget is that children have to be very active when we talk about alternatives. They have, first of all, have to take responsibility. They have to provide their consent. So we really ask a lot of children. And definitely when there is the restorative justice part as well, they have to look the victim in the eyes and other people they bring to the meetings. So it's really not at all a soft option. Other people, they dare to say, when children are placed in an institution or deprived of their liberty, that's very passive. The child just goes there and sits and waits till the sentence is finished, while diversion and alternatives really request the child to be active and to take responsibility. But unfortunately, it is true, most people see it as a soft option. Definitely the uninformed public, they always say, but that is easy, you steal a mobile and you get away with it. It's not true, and definitely not when there is a restorative justice component.
Okay, thank you. So before maybe, I would like to address the two questions that have been put in the chat box. We actually have a question from Marta Pascual. Hello team in Argentina. Many victims refuse restorative circles. Can we use indirect mediation? That's the first question we had. And then we have another question from Hale Gunay. So what do you think about the application of restorative justice for immigrant children's detention, especially main challenges in that sense? So those are the two questions that we have received. So Tim and Ingrid, feel free to answer.
Well, I can answer.
You answered. I see, Tim. Yeah, sorry, because I see.
But it's. I think this is a common question. People find that victims are sometimes reluctant. It seems a crazy idea. Why would I want to meet the person who's hurt me? What we found in Northern Ireland is we took great care in training the mediators or facilitators in how to engage with victims. That you're not asking the victim to come along for the benefit of the young person. They're coming along for their own benefit. And if they feel that their needs and their concerns have been really heard and they'll get an opportunity to talk about that, then they're more likely to come. So we have quite a high level of victim participation, up to 70%. But having said that, we do have victims who just do not want, they're frightened, or it's not convenient, it's not, they're busy. And so indirect mediation is an appropriate method in those cases. And for those who don't understand, that would be that the mediator would go between the two parties separately. They wouldn't be in the same room and bring messages to each until they have some sort of resolution. And that can work very well. Say the research would say that face-to-face meetings are always more effective, or well, when they go well, they're always more effective than indirect, but I wouldn't count out indirect. I have no experience of immigrant children's detention, so I would really need to understand the context and how it would work. I mean, my gut thought about it and understood the situation well enough, we could devise a restorative response to it. I know a colleague of mine, Vidya from Hungary, spent some time in refugee camps using restorative processes, and that went very well. So, but it's just not something I've done, so I'd be reluctant to give you a clear answer to that one.
We are coming to the end of thank you for this response. We're coming to the end of the webinar, but there is this last question from my dear colleague, also Marta in the MENA region, and it's about how can we progressively make restorative justice a more binding measure? And do you have any insight from your experience? And maybe to just address this question before we close this webinar today.
We had a great advantage in Northern Ireland. It became the law. And it was a very tough law, basically. It came out of our conflict, so it was a very special situation. There was an opportunity for radical reform. And basically the law said that children must be offered a restorative process. It wasn't the discretion of the judges, the social workers, the prosecutors, the police. The child had to decide. And of course, then the victim has to decide whether they want to do it. So I'm not sure how we managed to get such a law, but we did. That means we have a very high take-up. Other laws are less mandatory, but they do well. I mean, the general rule in progressive European countries is that judges are encouraged to use restorative justice. Places like Belgium, Norway, Finland, and they do have a good take-up. But the best way to do it is basically to pass a law, because judges, you know, generally will only do what the law tells them to do.
Okay, thank you. And Marta is saying she totally agrees. The law is the first essential step. So I would love to continue this conversation, like as if we would be in a cafe continuing this, but we came to the end of our webinar. So I would like to not extend the time, because I know everyone has different also things. And I would like to really thank Tim and Ingrid for your availability, your very informative PowerPoints and a presentation that give very good insight. There's just a poll that if you could just quickly, for my colleague Vesna, that is, it will really help us for our statistics for Child Hub and the webinar. So we would like to actually, we will keep you posted. You will receive the recordings after this, the PowerPoint presentations, and we will keep you posted for the next series that the next session that we will have. So we don't have a date yet, but really thank everyone very much. If you have questions, you can write to me and also the colleagues from Child Hub about also more specifically requests for Tim or Ingrid or the European Forum. Again, thank you very much, Edith, Emanuela, that has helped into setting up this this webinar, and Vesna and Tamash from the Child Hub platform, who help us with all the technical questions that we had, and we are happy to see that yeah, the Wi-Fi worked and we could hear each other and we could see each other. So this is great. So thank you very much, and yeah, take care everyone, and hopefully we see you soon in another setting. Bye bye.
Bye bye. Good evening.
Right.
Bye.